Imagine giving 35 years of your life to one company only to be let go in a 5-minute phone call. That's exactly what happened to Shawne Hopkins, a long-term employee at a Coca-Cola facility in Alberta. Now, full disclosure, these facts haven't been tested in court yet. I'm also looking at this from the lens of Ontario law because that's where I practice. While the provinces differ, the core legal doctrines are very similar. Now, there's quite a bit to cover, so I'm breaking this story into 3 parts. Today, we're looking at frustration of contract. In part 2, which should come out sometime tomorrow, we'll cover the duty to accommodate. And in part 3, we'll see how workers' compensation complicates things even more. One quick note before we go any further. Mr. Hopkins did work in a unionized environment. That means his rights are governed by a collective agreement, but the underlying human rights law and other legal principles we're discussing still apply broadly. Here are the facts. Mr. Hopkins was injured by a 900-kilogram door that caused severe injury to his shoulder, arm, and neck. He was on workers' comp for about 2 years. Then in early February of this year, Coca-Cola claimed the contract was frustrated and ended his employment. So, what is frustration? In law, you can think of frustration of contract as the legal death of the employment relationship. It happens when an unforeseen event, like a permanent disability, makes it impossible for the employee to ever foreseeably perform their duties again. The party alleging frustration must show that this unforeseen event radically altered the contractual obligations, was not foreseen by the parties, and which the contract itself does not contemplate, and was not caused by one of the parties. And just a quick note, when we say to be caused by one of the parties in this sense, we mean that a party has voluntarily done something, not that they were merely negligent in causing something. But here's the thing. It's not just about how long you've been off. In Canada, we look at the Naylor Test from the Supreme Court. We ask, has the situation become radically different from what was originally agreed upon? Which, for our purposes, is the exchange of labor for pay, where the permanent absence from employment would be considered a radical change. But if the absence is not permanent, or if there is a reasonable prospect of return, the contract is not frustrated. Another feature is that frustration is technically what we call an operation of law, meaning it happens automatically. But that doesn't mean you're out of luck if you're an employee. In Ontario, we have a safety net with the Employment Standards Act. And under Section 54, and based on how courts have interpreted this section, frustration due to illness or injury is still a deemed termination. This means that even if the contract died on its own, by an operation of law it ended, the employer isn't off the hook. At a minimum, you are entitled to statutory notice and severance pay. And just as an aside, severance pay is different from termination pay, but it's been largely interpreted in the same way. For a 35-year employee like Mr. Hopkins, that's statutorily guaranteed 34 weeks pay in Ontario. And according to CBC, Coca-Cola reportedly offered him just a few $1,000s in exchange for a signed release. And apparently no statutory notice, although the article is silent on statutory notice. So was this a valid frustration? Well, the burden is on Coca-Cola to prove it. But since the Alberta's Workers' Compensation Board actually cleared him to return to work, albeit under different duties and with retraining, the frustration argument looks weak from the start. That leads us to our next big question. Did Coca-Cola actually try to help him get back to work? Join me in part 2, where we break down the duty to accommodate and the high bar of undue hardship. In the meantime, check out my blog, linked below, where I cover the cases and legal concepts I drew on for this video in much more detail. And like and follow so you don't miss part 2.